So the topic I'm going to discuss is related to legislative relations between center and state in India. And the topics covered in this aspect is the introduction, territorial jurisdiction, which covers Article 245, and the subject matter is related to the jurisdiction, which is Article 246. Then residuary powers, Article 248, then doctrine of repugnancy, Article 254, and Parliament's power to legislate on state subjects. Now, coming to this, the introduction is what are legislative relations? The legislative relations refer to the division of law-making powers between the Union and states under the Indian Constitution, which is basically defined primarily through the Article 245 to 55, 7th schedule, which includes the union-based, state-based concurrencies. Then they determine who can legislate on which subject and under what condition the center may legislate on state subjects. So, if the center and state have three heads, that is legislative, executive, and financial relations. Legislative is the law-making purpose, and the executive is the center and state, where the situation is different. See, then financials have discussed already. So the importance it maintains the federal balance. It's like ensures neither the center nor the states which oversteps their legislative domain. And the national unity, it's like the uniform laws on national matters which promote coherence, stability, and coordinated governance. Then the state autonomy allows states to address regional needs, local priorities, and diverse socioeconomic conditions. The prevention, it's like it prevents a legislative conflict, it clears the distribution, reduces overlapping powers and constitutional disputes. The territorial jurisdiction is covered in Article 245, which states the extent of laws made by Parliament and states. Text of Article 245, which is the subject to the provisions of this Constitution. The Parliament may make laws for the whole of any of the country, which obviously we know that the Parliament is it has to make the law. But the Constitution in the territory of India and the legislature of the state, it may make laws not only like whole of the country, but a particular state, the laws have been made. So no law made by the Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. As we know that like legislative relations, as we see that the key principles like the Parliament is the core territorial power, state legislatures, and territorial limited unless a sufficient nexus exists. So the legislative relations is included in Article 245 to 255 in Part 11, which says so the territorial extent, the distribution of legislative subjects, parliamentary legislation state fields, and the center's controls over the state legislature. This is basically given in 7th schedule, and the three lists I've already discussed. So the significant case related to it was that the state of Kerala and others versus Maraprem Kuri. This is a case of 2012. So the court reaffirmed that Article 245 defines the territorial ambit of what the legislative power of parliament and states. So basically, it is defining what territory and what is the role of the legislative powers and what is the role of the parliament and state. And nobody should be like overruling, or it's like if there is a doctrine of equity, then which will overrule and which will override, which power will be override. So the implication is that state laws with extraterritorial operation need to be struck down, and unless a real and substantial territorial nexus exists. Nexus like if there is an intersection, there is some relation between the laws made by the parliament or any state. So the doctrine of territorial nexus comes into existence. Now the theory of territorial nexus. Under Article 245 of the Constitution, the Parliament makes laws for the whole or any part of the country. This is very clear that obviously Parliament is making a law. Then, if there is any extraterritorial operation, the state legislature will make laws that will only be confined to its territory. But the doctrine of territorial nexus is a constitutional principle. Why? Because in India, it allows the state legislatures to have beyond its territorial boundaries only if there is a real and substantial connection and between the state and the subject matter of this legislation. So the subject matter, what they are talking about, it's like if we talk about the territorial extent only, so the parliament, whole India applied. So state legislature, it's like, for example, if the Rajasthan. Okay, so Rajasthan has made a law, something which will be only implied in Rajasthan, not in any other state. Or for example, if we say the laws which can be amended, yeah, Bihar is a dry state, as we all know that. So if someone is doing illegal alcohol supply there, so the laws made in Bihar that will prevail, and the person will get Like if that person is from somewhere else, any other state, doesn't matter. So because he is doing that unlawful illegal act in Bihar, so the law will prevail of Bihar itself. So you cannot say that I belong to such and such state. So the this is the subject matter. So we are basically focusing what is the main crux and what is the subject matter, and according to it, we are going to deliver our or take the steps, and the judgment has been made. Then there is a case study of the state of Bombay versus RMD Chamar Bogwala. So this is a landmark case, and it states that Lotteries and Prize Competitions Act was sought to levy tax on prize competitions printed and published outside the state, but it was circulated within the state. So the respondents challenged that the law on the ground that it was ultra virus. How it is ultra virus? Because it is purported to apply extraterritorial without proper legislative competence. So the Supreme Court said that the state's law holding that there was sufficient territorial access, basically there was an intersection and it was overriding. So the prize competitions was circulated in the state, entry forms and fees collected within the state, and therefore the state had the legislative competence to tax that activity. So it was the state could have tax. You cannot say that we have to live by this tax because we don't belong to that state. Doesn't matter. It is related to the competence, and the state legislative have given the tax activity according to it, and where this competition was or lottery system was done. So this was the landmark judgment regarding this. Now, if we come to Article 246, which is the subject matter of jurisdiction. So this article outlines which subjects, that is the Union Parliament and the states, can legislate upon through three-list scheme that is given in 7th schedule, and I have mentioned earlier. First one is Union list, list 1, then state, then concurrent list. So clause 1 says that Parliament have exclusive power over matters in the Union list. It says basically that it will overrule the Union list if there is anything contradictory, and it will override the power of the Union list. Whereas in clause 2, both the Parliament and state legislatures have to legislate, and the concurrent list subjects can be overpowered. Then clause 3 says that exclusive power, which is only like over to the state list subjects. So these basically exclusive powers are given to the state, which can be amended, but it cannot be amended by any other state or the Parliament. This right has been given to the President. So it is if the president is agreeing on that subject list or any if anything which is in favor of the public domain and in favor of the state, then that will be overridden. Then clause 4 provides that the Parliament may legislate for any part of India not included in the state, even if the matter falls under the state list. So it's like so it says that Parliament's decision will override what the state and the other list. So whatever Parliament, if anything it is in contradictory of the Parliament judgment or like Parliament decisions or the list or activities, then obviously it will override. Then Article 248 is residuary powers of legislation. It grants the Parliament exclusive power. Exclusive power to what? To make laws in respect of what? Which the laws which are not touched by the state or concurrent list. And even if there is a contradictory issue comes between the state and concurrent list, then exclusive power is given to the Parliament that with the 2/3 of the majority, it can be passed. Clause 2 explicitly includes the power of imposing taxes on matters not mentioned in those lists. And the case law related to is the doctrine of residuary powers, which was discussed in Hari Krishna versus Union of India and others, where the courts held that the Parliament can legislate on subjects, but it cannot be covered, which are not covered in the list. So, and there was also extraterritorial if we talk about the legislative relation, then we have extraterritorial as well, which says that Indians, if, for example, if there is an Indian who is living in a foreign country and he or she has done murder and he or she comes back to India, doesn't matter. This is the power given to the Parliament that that person will be convicted and that person will be charged for the murder. So this is the power given to the Parliament that they can impose and they can enact the laws according to it, and the accused will be convicted for the murder. Doesn't matter that the person is does the murder outside India or within the India. That will be same, and this comes in the extraterritorial powers, which is obviously given to the Parliament, can be taken into account. Then cases where Parliament is not applicable is that the President has got the power to make regulations in duties. So union territories, as you know, like Andaman and Nicobar Islands, Lakshadweep Island, rather in the Nagar and Haveli, Daman and Diu, and Ladakh. So in this, the president can amend and repeal the regulations. So parliamentary power to legislate in state subjects, as I said earlier, it is covered in Article 249. This is the power of the parliament to legislate the national interest. What is the national interest? Anything which is obviously done according to the scenario with for the benefit of the people and which is obviously large. So the Rajya Sabha passes a resolution which is supported by two-thirds of the members present in voting and which is necessary and create in the national interest. And Parliament should make laws with respect to any matter related within state law, that it shall be unlawful for the Parliament to make laws for the whole or any part of the history of India with respect that matter so long as the resolution remains in force. So what they are talking about, the resolution remains in force, there comes the emergency. If the law is enacted or if there is enacting an emergency, so that will be repealed. But the thing is, as soon as the emergency has been done, inducted, then after 6 months, that will be ultimately it will be like not continued, and it will remain in force for 6 months until it has been reviewed and reinforced again. Then such a resolution normally lasts for a year. It may be renewed anytime and get paid a year at a time. So here it is given for a year, but it's like 6 months has been given. After 6 months, we have to get it renewed. Article 250 is like the power of Parliament to legislate during a proclamation of emergency. While the proclamation of emergency is in operation, the Parliament shall have the power to make laws for the whole or any part of the territory of India with respect of all the matters in the state list. So, because state list, what is being given? For example, it includes a public order, the police, public health, institution, agriculture, etc. So, in this list, whatever laws has been made, it has been proclaimed according to the state. Such a law, however, shall seem to have effect on the expiration of 6 months after proclamation of emergency place to operate. Then it has Article 252, which states the Parliament power to legislate with a consent of two or more states. If the legislation of two or more states pass resolution with the fact that it is desirable to have a law passed by Parliament on any matters in the state, it shall be lawful for Parliament to make laws regulating that matters. So what it says is law, the Parliament has been given that much authority that it can regulate in any matter which is not overriding it, but it is for the public welfare. Doesn't matter whatever state is giving it power, if it is for the public welfare and if it is contradictory to the public at large, then the Parliament can take it in action. Any other state may adopt such a law by passing a resolution to the effect. Such law only be amended or repealed by the Act of Parliament. Now, it is very clear that only Parliament can act on it, amend or repeal only if it is something or it is coming in the functioning of the Parliament or if it is not beneficial for the public at large. Then Article 253 states that the Parliament's power to legislate for giving effect to treaties and international agreements. So it empowers Parliament to make any law for the whole or any part of the territory of India for implementing the treaties and international agreements and conventions. In other words, the normal distribution of power does not stand in the way of Parliament to pass a law for giving effect to international obligations, even though such laws relate to any of the state lists. It also enables the government of India to implement all international obligations and commitments. Whereas in Article 256, it states that the Parliament's power to legislate in case of failure of constitutionality in state. Article 256 of the Parliament is empowered to the Parliament is empowered to make laws with respect to all the matters in the state list when the Parliament declares that the government of the state cannot be carried on in accordance with the provisions of the Constitution. So basically, they are not the Constitution, they are just taking into account the because we can change the basis. We can amend it according to the will. Or which is for the welfare of the people of India. So now the doctrine of recognition, which is in Start 3054, the minimum scope of this law is that the doctrine it comes into play when both the law made by the Parliament and the law made by a state legislature apply to the same subject matter. Same subject matter means, for example, I have given you the subject matter related to the sexual marriage of privacy, that the person is doing illegal alcohol thing. So, what is the same subject matter that the person is accused of the illegal things done by him, and doesn't matter which that the state allows it or the Bihar doesn't. So this is also given in the content list in the seventh schedule. If the two laws are inconsistent in the provision such that one cannot operate without conflicting with the other, then the doctrine directs which law will do. So the work of this doctrine is that if there is any conflict between the two provisions given by the two different texts, then the doctrine will come into existence, and this conflict it will be decided that which is the better law, and that law will prevail accordingly. So under Article 254 Clause 1, if a state law is repugnant to a valid parliament law or an existing law on a contrary matter, the union law prevails and the state law is void to the extent of the inconsistency. So if we discuss if the conflict with the both parliament and state legislature to make the law, and there are 52 subjects which originally they were 47. For example, in the subject we are talking about relates to the criminal law and procedure, civil procedure, marriages, divorce, etc. So these are the subject matters which have been included in the contract list. Exception to this article is that, however, Article 54 clause provides an exception. It says that the state law which is repugnant to earlier union law may nevertheless prevail in the state if it has been reserved for the precedent's consideration and has received the precedent sense. So it clearly states that if there is if there is a consideration given by the president and there is an attempt given by the president, that it cannot be repealed. It can only be amended accordingly with the changing scenario and the evolution. It can be changed because it was reserved because it was the decision of the president. So the amendments can be done, it cannot repeal it. So this is the one exception. Even then the parliament retains the power to enact a new union law on the subject, which will again prevail over the state law. So what it says that whatever state law has been given and whatever decisions have been taken, the laws have been made, it can only be amended according to the parliament, and that can only be enacted and written only if it is not contradictory or overriding the other laws. Key features and tests for the same subject matter criteria related to that recognizing rights only both laws related to the same subject in the concurrent list, not many similar or allied acts. So the subject matter should be same, only the ideologies are different. Same the Bihar case, as I have discussed, the ideology there is different, ideology where it is different, like in Delhi it is different, Noida it is different, everything is different. So you cannot impose your decision on any other state or union. So inconsistency tells the concept must be direct and irreconcilable. Mere overlap or incidental impact does not amount to recognizability. Clearly says that you can conciliate, but overlapping should be basically the impact should be positive, not a negative. So if there is any incident which goes in the negative direction that or it creates any conflict between the states, then that should be reviewed and that will be declared not valid. Then we have temporal equivalence. It does not matter whether the union law or the state law is earlier, it recognizes the union law prevail unless Article 254 clause 2 applies. Presidential listening safeguard is that the state law can override the union law in its state only if it obtains the president's assent under Article 254 clause 2, because without assent, it is void to the extent of the recognition. So in all this, the subject matter, it is like the president's assent is very important because without his assent, anything which should be done that will be repealed because it may or may not be for the public welfare. Then landmark case related to this M. Karunathi versus India. This case clarified the doctrine, confirming that in the state law the union law both occupy the same field in the constitution are repugnant. The union law must produce with the state law and the precedent in under the 54 clause 2. So all these things which I have discussed earlier was given in this case and it was clarified and it is fine in this case. It is what the role of executives, what will be the list, concurrent list, what will be the subject matter, obviously the current situation, and which will be repealed or which will be amended. Another important decision is forum for people's collective efforts versus State of Bengal 2021, where the Supreme Court struck down a West Bengal Act as repugnant to a Union Act, applying the doctrine strictly. So these are the two major landmark cases which has been given. So this was the case of 1979, this is the 2021. So, with all this, we also have the 42nd Constitutional Amendment Act 1976, which transferred the 5 subjects to the content list from the state list. This is very important in nature. So, the first one, the 5 subjects is the first one is education, second one is forest, third one is weights and measures, fourth one is protection of wild animals and birds, the fifth one is administration of justice. This is a constitutional organization of all the courts except Supreme Court and High Court. Then we also have a residuary subjects, which is the parliaments have the power, which is given in Article 248. For example, if we talk about the AI is not yet been given in, it's not yet been covered. So the territories are, so this AI can be the part of the residuary subjects for which later on the many amendments can be done or new laws can be made. Then we have the territories which are not part of any state, so the parliament have the power. And we also have the 101 CAA of 2016, which includes the goods and services. So the parliament and state have the power to make laws, as you know. The parliaments have exclusive power. These are the laws made for the GST purpose. And it is basically in the state trade relations, which the parliament having them the power that they have to look in according to it. So, and if there is so the crux of all these things is that if two or more things overlap, or if there are laws which are overlapping, and there are two or more subject matter which are overlapping, or the decisions have been made between the two states, and they are not coming to the same level, the same page, then obviously the dominance level will be first, we can say, the priority will be given to the union, then the conference list, and then the state. So that's it from my side. Thank you.